Hello, everyone, and welcome back to ME-Arcone Queing, the podcast by the Institute for Alternative Dispute Resolution, New Delhi. This is episode 3 of season 15. And if you have been with us this season, you already know what we're trying to do here. Move past the textbook definitions and actually talk about what dispute resolution looks and feels like once you are in the room. I'll be honest, today's conversation is one I have been personally looking forward to. Our guest has sat at the head of the table as a sole arbitrator in over 1,000 cases. And what I'm most curious about is not just the legal side of it, but the human side. How do you get two parties who don't trust each other, who don't understand each other, to walk away with an outcome they can actually live with? Now, quickly before we dive in, our viewers, if you enjoy these conversations, do hit the like button, drop a comment, and share this with someone who is thinking about a career in ADR. It genuinely helps us reach more students like you and me. I am Priti Gill, a third year law student and also an intern at the Alternative Dispute Resolution Institute, New Delhi, and I'll be your host for today. Now, let's get into it. This season's theme is Voices of Resolution, promoting harmony through communication and understanding. And if there's one thing that the theme keeps pointing back to, it's this, that the resolution is not just a legal outcome, it is also a human one. Two parties walk into arbitration as strangers and sometimes as adversaries. And somehow, through the process and after talking, they walk out with closure. That does not happen because of clauses and citations alone. It happens because someone in that room knew how to listen and how to ask the right question at the right moment, and how to make both sides feel heard, even when only one of them technically wins. For today's episode, I want to take that broader theme and narrow it down to something specific. Let's call it listening beyond the law, what communication really looks like inside arbitration and mediation. And honestly, I can't think of anyone better placed to take us inside that world than our guest today. So let's get to know him first. Our guest is Advocate Hitesh Ramchandani, an international accredited arbitrator, mediator, and conciliator with over 12 years of experience across commercial, banking, IT, construction, family, and also employment dispute, amongst many others. As a sole arbitrator, he has presided over more than 1,000 cases and he has mediated an impressive number of disputes outside the courtroom as well. He is impaneled with the Honorable Bombay High Court, the Chandigarh Arbitration Centre, and serves as an expert with the Arbitration and Conciliation Centre, Bengaluru. His practice also extends internationally, with empanelments across arbitration centers in Malaysia, Hong Kong, Vienna, and beyond, alongside his work with the several online dispute resolution platforms. Welcome to the show, sir. It's truly wonderful to have you with us. This conversation, I would like to start at the very beginning, if that's okay. You have presided as a sole arbitrator in a number of cases. And honestly, that number alone makes me want to know how it all started. What first drew you to arbitration as a career path? And thinking back, how has your approach to writing an award changed from those early years to where you are now?
First of all, I would like to thank you for inviting me to this podcast. Well, my journey into an arbitration began during my practice as a lawyer. I regularly saw litigants spending years in courts waiting for their disputes to be resolved. They invested not only their money, but also their time, energy, and peace of mind. By the time justice was delivered, many of them were emotionally exhausted and financially burdened. I realized that parties are not only looking for justice, but also they are expecting that their disputes to be resolved quickly and efficiently. This inspired me to shift my focus towards alternative dispute resolution, particularly in arbitration, because it provides parties with a faster, efficient, and resolving disputes while maintaining fairness and due process. From the very beginning, my priority has always been the same to ensure that every award is legally sound, fair, and based on the facts, evidence, and applicable law. That principle has never changed. What has changed over the years is my experience. Today, I am able to identify the key issues more quickly and focus on truly relevant for deciding the dispute. Experience has also taught me that a good award is not about the lengthiness, but about its clarity and reasoning. As an arbitrator, I believe that every party deserves that they may be heard, they be heard fairly. And while deciding an award, I carefully consider every important argument that they have made by both the parties. Even if one party is unsuccessful, they should feel that their case was heard fairly and decided impartially. I now place greater emphasis on writing awards that are well structured, easy to understand, and clearly explain the reasons behind the decision. I also ensure that every important contention raised by the parties is properly considered and addressed.
That is such a grounding way to look at it, sir. And it actually leads into something I have been wanting to ask, that there's a common assumption that being a good arbitrator simply means being a good lawyer. Know your law, cite your precedents, and you are set. But the role also asks for neutrality, patience, and the ability to make tough calls under real pressure, often with both parties watching closely. So, from where you sit, what are the skills that don't really show up in textbooks but end up mattering the most when you are actually in that chair?
I believe that being a good lawyer and being a good arbitrator are two different roles. A lawyer represents one party and put forward the strongest possible case for that client. But an arbitrator, on the other hand, has to remain completely independent and impartial. An arbitrator has to listen to both the sides with an open mind and decide the dispute only on the basis of the facts, evidence, and the applicable law. In my opinion, neutrality is one of the most important qualities of an arbitrator. Both parties should have confidence that they will receive a fair hearing and that the decision will be made without any bias. Another underrated skill is managing the proceedings efficiently. An arbitrator must ensure that both the parties get a fair opportunity to present their case while also discouraging unnecessary adjournment and delays. Another important skill is the ability to analyze facts objectively. An arbitrator should not be influenced by emotions, assumptions, or the status of the parties. Every case must be decided solely on the basis of the evidence, the contract, and the applicable law. In my opinion, uh, an arbitrator also have the legal knowledge, which is very essential, and the quality should have impartiality, patience, careful listening, sound judgment, and integrity. These are the qualities which make you as a good arbitrator. Finally, an arbitrator must have the confidence to make difficult decisions. Not every decision will satisfy both the parties. But if the decision is fair, reasoned, and based on the law, the arbitrator should not hesitate to make it.
I think that's something a lot of us don't fully appreciate until someone like you points it out to us. Now, shifting the gears a little, your empanelments are just not limited to India. You are connected with arbitration centers in Malaysia, Hong Kong, Vienna, the Maldives, and quite a few others. So, from what you have seen across these different jurisdictions, how does arbitration practice in India compare? Are there some things we are doing differently here, maybe better in some ways, or areas where we could learn from how it's done elsewhere?
To be very honest, I don't see it as a comparison between India and international forums. The core principle of arbitration remains the same everywhere. What international exposure gives you is a broader perspective. You learn different ways of managing proceedings, interacting with parties from different legal and cultural backgrounds, and adapting to different institutional practices. While every institution may have their own procedures, the fundamental principles of arbitration remain the same, that is, fairness, impartiality, party autonomy, and a reasoned decision. I believe India has come a long way in promoting arbitration. Today, we have experienced arbitrators, highly skilled legal professionals, and a judiciary that has played an important role in supporting and strengthening the arbitration framework. The confidence of businesses in arbitration has also grown significantly over the years. What I appreciate most is that India is continuously evolving through stronger institutions, greater use of technology, and a growing arbitration culture. We are steadily aligning ourselves with global best practices. With these developments, I am confident that India has the potential to become one of the leading arbitration hubs in the world. Having said that, I believe India has some significant strengths as well. We have highly skilled legal professionals, experienced arbitrators, and a judiciary that is increasingly supportive of arbitration. Indian arbitrators regularly handle complex commercial disputes and are fully capable of meeting industrial international standards. Ultimately, whether the arbitration is in India or abroad, the core principles remains the same. That is fairness, impartiality, efficiency, and delivering a well-reasoned award. These principles are universal and should always guide an arbitrator.
That is such a useful insight, sir, especially for those of us who have only really studied the Indian side of the framework. And speaking of how things are evolving, you're also associated with platforms like Jupiter's Just Act and WebNyai, which are part of this growing online dispute resolution movement. How do you see technology reshaping arbitration and mediations going forward? And particularly, could online dispute resolution be the answer for smaller commercial disputes that right now probably never make it to the formal ADR at all?
Well, I believe technology plays a very important role in the future of arbitration and mediation. In fact, we have already seen how virtual hearings and digital case management have made dispute resolution faster and more convenient. Online dispute resolution has the potential to make ADR more accessible, especially for small commercial disputes. Many businesses and individuals hesitate to pursue legal remedies because the value of the dispute may be lower than the cost involved. Here, ODR provides them with a practical and cost effective solution. It also saves time and expenses. So, parties from different cities or even from different countries can participate in hearings without being physically present. This makes the process much more convenient. I believe technology can improve efficiency, but qualities such as fairness, impartiality, sound judgment, and human understanding will always remain at the heart of the arbitration and mediation. Going forward, I believe ODR will become an integral part of the ADR ecosystem, particularly for smaller commercial disputes. It will make dispute resolution more accessible, faster, and more affordable while still preserving the core principle of justice and fairness.
That's a really hopeful way to think about access to justice, sir, honestly. And I want to close with something a lot of our listeners are probably thinking about right now, myself included. For young lawyers and law students who are drawn to arbitration and mediation as a career, but don't quite know where to start and how to do it, what would you tell them? What does it actually take to build the kind of profile, credibility, and experience that this field demands?
Firstly, I would encourage them to actively participate in arbitration mediation competitions, including moot court competitions. These competitions help develop advocacy, legal research, drafting, negotiation, and problem solving skills. I would also encourage young lawyers to intern with experienced arbitrators or work as a tribunal secretary or a case manager within arbitral institutions. These opportunities provide valuable hands-on experience and help them understand how arbitration proceedings are conducted in practice. I would strongly encourage young lawyers to enroll in specialized ADR courses, particularly that is Tribunal Secretary course and a case manager training programs. Today, many arbitral institutions require trained tribunal secretaries and case managers to assist in administration of arbitration proceedings. These roles provide valuable hands-on experience, allowing young professionals to understand how arbitrations are conducted, how hearings are managed, how procedural orders are issued, and how arbitral awards are prepared. This hands-on experience helps young professionals develop practical skills and gain valuable exposure to the arbitration process.
So, this conversation has given me a lot to sit with. I think what stands out most is that behind every one of those 1,000 plus awards, there was a moment, maybe several, where someone simply chose to listen a little harder, explain a little more patiently, or ask one more question before deciding the award. That, to me, is what Voices of Resolution is really about this season. Thank you so much for being on ME-Arcone Queing today and for being so generous with your time and experience. To everyone listening, if this episode gave you something to think about, do press the like button, comment and share it. Send it to a friend, a classmate, anyone who believes, like we do, that harmony often starts with how we choose to talk to each other. We'll see you in the next one. This is Mia Conquing, and the conversation is just getting started.
Thank you.